Hi, my name is Georgia Lennon, and this week I'm continuing on with our family law alphabet series with the letter F. So there's two words that I'd like to speak to you about today. One is financial disclosure and the second is financial agreements. So really briefly, the first is financial disclosure. This is a really important issue to discuss in all family law matters because financial disclosure is relevant to the financial circumstances of both parties, which particularly for matters where we're dividing assets that have been part of a relationship or a marriage, it is obviously quite essential that we know what each party has brought into the relationship, what each party accrued during the course of the relationship or spent, and then what's happened since separation. So financial disclosure is a requirement irrespective of what court you're involved in, and the obligation commences on both parties to provide information and documents relevant to their financial circumstances from as soon as the matter begins. So that can often begin even if you're just having informal settlement discussions and proceedings have not yet actually been commenced. So often when you start a matter, you'll receive a letter from the other side or your solicitor saying, please provide us with all of these documents. And it can seem quite overwhelming, and it is a bit of a cumbersome task to have to collate all of that information and provide it. But it is absolutely essential, otherwise you don't really know what there is to divide. And it's also essential because if you're entering into orders or a financial agreement, one of the only ways in which some of those agreements or orders can be undone is if there has been non-disclosure. So it is absolutely essential that financial disclosure from both parties is provided in all family law matters. And it's a common term that you hear a lot, which is why I wanted to speak about it today. So the second word is financial agreements. So a financial agreement can take place in three ways. So you'll probably hear lawyers calling them BFAs or prenups. That's more of an American kind of terminology. And BFA stands for binding financial agreement. So the legislation actually calls them financial agreements. They're only binding if they're drafted correctly, which hopefully yours is. So as I said, there's three ways in which they can be drafted. So there can be essentially a prenuptial agreement. So essentially that is before the commencement of your relationship, you enter into an agreement providing for what is to take place should you separate. So that can apply for de facto relationships or marriages, as can these other two as well. So the second is a binding financial agreement entered into during the course of a relationship. And the third is one that's entered into following the end of your relationship and or divorce. So the third is probably the most common in that a lot of lawyers are sometimes hesitant to do the first two because of it's a little bit tricky. You haven't actually separated yet and you're kind of trying to predict what's happening in the future and what is going to be fair and equitable at that time. And you may in fact be opting out. Well, you're opting out of your opportunity for the Family Law Act to actually determine what should happen should you separate. So there's the three types of agreements you can enter into. So one of the things that you often see with the first two types of agreements, so one entered into before a relationship or during, is that you'll often see a party where they have a lot of financial resources want to protect those. So one of the ways in which you can do that is to simply just quarantine your assets versus the other person's assets, and you both keep what you came in with. In my view, that would be inherently unfair because as the relationship evolves and you don't know how long that's going to go for, you're both going to be making different contributions. So it's really important for you, your lawyer, if you're considering entering into one of those kinds of agreements, to give you some really detailed advice in relation to firstly what you are in fact opting out of, i.e. what could you get potentially at each different stage should you separate and the Family Law Act determined it versus what you would get pursuant to the agreement you're proposing to enter into. Because it is very, very serious to enter into a private agreement that essentially says, don't worry about what the law says, this is our own thing over here. However, there is a place for these agreements, and that is where both parties have received that advice, and they're very commonplace in second relationships where both parties want to keep their assets separate, or to an extent separate, so that they can maintain both of their respective assets and super and so forth for their respective children if they have them from a former relationship. So there is certainly a place for these agreements. It's just really, really important that when parties enter into them, they're given really, really thorough advice, and that you as an individual really understand what it is you are entering into. So they are the two F words, probably the most commonly used ones in family law, other than the Family Law Act itself. So next time we'll be talking about words with the letter E, so tune in. Thanks for listening.